So as ever with these sessions, we have got a great deal to get through. So we're going to start as we mean to go on and get through this at a reasonable clip to leave a little bit of time for questions. So here's the summary. We're going to recap what's been going on so far in this process of moving towards the new regulatory standards and approach, focus particularly on the outcome of the consultation and what, if anything, has changed as a result of that. Some things have, and some things specifically haven't, and equally of interest, both of those. Let's look at where the standards and the code of practice have actually landed. We have the new regulating the standards 2024. So we have got effectively the regulatory mission statement from the regulator of social housing. So we can take a look at that, try and pull that together. And then we get to the important bit down in the bottom right, the in practice section, which is where I throw open the door of the ivory tower of governance and we let Paul come in and talk about what actually happens in practice, in the real world, real tenants, real complaints, real situations in which you have to work in your jobs. So hopefully we can make that as accessible and as useful to you as possible. And we've got some scope for questions at the end of the session. So let's begin with the recap. And any excuse to break out once in a lifetime by talking heads. But you might ask yourself, how did you get here? You might also ask yourself, this is not my beautiful house, for fans of the original song. And if it isn't your beautiful house, then you don't need to make a complaint about it. So at least that's one less. But there has been a process, lest we forget it, that brings us to where we are today. And it's worth just quickly taking a second to realize, how did this thing get started? What's the direction of travel? So it starts with the housing white paper, the introduction to which I have to confess still annoys me every time I read it. So I've stopped reading it now. It's set against the background of some events that nobody in social housing would ever have wanted to happen to any tenant of any RP. However, what that has given rise to is a considerable head of steam towards more transparency, more regulation, more enforcement. That seems to be the thesis of the Housing White Paper. That turns itself into legislation in the Social Housing Regulation Act. That changes the mandate of the social housing regulator and requires it specifically to do certain things. What the regulator then does is launch the consultation to look at the regulatory standards and the statutory guidance on enforcement. During that process, the government issues further directions to the regulator, particularly around about complaints, telling it what needs to go in the standards and not requiring it to consult on those. February 24, and not early February 24, we get the new standards and policy. We get the code of practice published, and then it's all going live on the 1st of April. And yet that 1st of April, the one that's happening next week. So lots of process, lots of momentum. And to put this into context, for those of you familiar with my presentations, the world of regulatory pain slide. And this is a little bit of an illustration of just how regulated it is to operate as a registered provider. You have my absolute sympathy doing this because the regulation on law firms is as nothing compared to this. And there you are in the middle of it. There's the RSH above you. There's the Housing Ombudsman, but they are not the only organisations you need to concern yourselves with. There's a whole raft of regulators sitting up there. You've got funders who have an input into how the organisation is run. You've got contractors who are the means by which you deliver it. We're certainly coming back to mention them later on in the session. And then at the bottom, you've got your staff and your tenants, all of whom are your responsibility. And all of that is filtered through what's coming down from the regulators above. So don't lose sight of the bigger picture. Certain parts of this diagram will be particularly relevant as we work through the session today. That's there just to remind us we mustn't lose sight of the bigger picture as well. And while the regulator talks about its co-regulatory approach, this is more than co-regulatory. This is at least tri-regulatory, if not more. Because we've got another player who's come onto the pitch during this process. You've got the Housing Ombudsman Service. So where does that fit into this process? You are in the intersection between the two. And right here, while the consultation is live, on the 23rd of January this year, the Housing Ombudsman publishes its Spotlight report Towards a Relationship of Equals, talking about how it believes that there needs to be fundamental change in the sector about how vulnerability and the diverse needs of tenants are handled, and making a number of interesting comments about what the Ombudsman considers to be good enough, which I know Paul's going to be picking up in his in practice session later on, because we've been discussing that before the session started this morning. Paul, there appears to have possibly the world's largest pen, because there's an excellent bit of foreshortening on that. There it is. So you know that those notes that he's taking are going to stay taken. So we've got the Housing Ombudsman coming in as well, and that does make a difference because it sheds a light on not only how the regulator's setting up to deal with consumer standards following the 1st of April, but also what the Ombudsman thinks is going to be good enough. And the Ombudsman committed to this while the consultation was live and before the final version of the regulations was published. So I think we can say the Ombudsman has formed a view on where it's going with this. So this is the section we're in. We've got the directions, we've got the new standards, the consultation's over. What happens now? So let's briefly pick up at the very end of the Consumer Standards Consultation Decision Statement, paragraph 12, the final position. So all RPs must deliver the outcomes and expectations in the consumer standards. So that's private RPs, local authority RPs, large ones, small ones, everyone. The financial standards don't necessarily apply to everybody in the same way, but the consumer standards absolutely do. So whatever kind of RP you are, this is for you. And it applies to social housing. So I know we do work fairly regularly assisting RPs with filling in various returns to the regulator, describing how much social housing they've got of which kinds. And that's just to make the point there. If you're not sure whether a particular property that you have is social housing or not, make sure and find out, because all of these standards are in play if it's social housing. There's a little bit of an exemption down the bottom there for shared ownership properties not fully staircased, and that's about as good as it gets in terms of exemptions. Pretty much all social housing is within the remit of these standards as we now find them. So what was the outcome of the consultation? Well, by far in number, the largest cohort of respondents were individual tenants, of which there were 656 out of hundreds of thousands all over the country. 185 private RPs and 98 local authorities responded, which I might venture to say in percentage terms is a far higher turnout than there is for tenants. However, this has been done on a one person, one vote basis. So the regulator is in a position to say that between 85 and 89% of feedback is positive. And that is not quite Russian election standards, but it's a pretty high number. And accordingly, the regulator is happy to see that there is overall positive feedback. If it is one person, one response, then a lot of that percentage, it quite understandably is a number of tenants who are interested enough, motivated enough to respond, saying, yes, I want more transparency, I want more regulation, I want better treatment from my landlord, of course I do. And I can't imagine any of those individual tenants have said, no, absolutely, this is asking too much. So fair enough, that's the result. Those stats are what they are. We've got 4 revised consumer standards plus a new code of practice for consumer standards. Wasn't one of those previously. The latest government direction was about rights and complaints. That hasn't been consulted on because the government waived the requirement. That's gone straight into the relevant standard, and we'll pick that up in a moment. The language of the decision document is about updates, clarifications, expansions, no major changes. These are largely the standards as you've seen them, and we're not going to take a lot of time today reading out what's in those standards because you've seen them. What I'm going to do is pick up on what's new, what's changed. And then we've got the new regulating the standards 24, which isn't available as a download yet. It's available as a cluster of web pages. So fortuitously, the cut and paste feature in my browser is still working. So I've got a documentary version of it. And until it goes live on the 1st of April, I guess everyone else is having to do it the same way. So let's then take a look at where we've landed on those consumer standards after the consultation. It wouldn't surprise you to hear that there aren't an awful lot of songs that I was able to find on the subject of regulatory standards, but I have turned up this country rock banger by Ashley McBryde, One Night Standards. And as you can see from the quality of the pointing over that door, there is potentially a certainly low rent residential element to this song. So it's going to have to serve for today's purposes. So what in the various standards is new since the consultation? So let's start with the safety and quality standard, previously known as the home standard. So key point here is where a third party is legally responsible for the maintenance of homes and communal areas, the landlord is still responsible to the tenants, specifically to hold that third party to account. The other item that hasn't changed is that the right first time repairing requirement is still removed, and the regulator has declined to introduce anything specific in terms of an absolute standard as to how long a repair should take. So that's fine, as is a theme we've seen throughout a number of these standards. It's up to you. You've got to figure out what compliance with the standard and the specific expectations looks like where you are. And again, this is not the last time I'm going to say with my procurement lawyer hat on, if it's still your responsibility to hold to account the person who is legally responsible for maintaining homes and communal areas, get it in your contract with that management or repair or maintenance provider. Procure that compliance with the standard from the start. Don't try and replicate it, just say, don't get us in trouble with the regulator in relation to that standard. We're passing that responsibility down in a contractual sense. That's the right approach there. We've then got the transparency, influence and accountability standard, so previously known as tenant involvement and empowerment. So fairness and respect extends now to prospective tenants. That's a key point that came out in the feedback, and the same point there about diversity. Anybody who hasn't yet become a tenant, but is engaging with your organisation. So applications for tenants, people coming to you via choice-based letting, inquiries, anything like that, any prospective tenant is also caught by the standards and deserves the same level of treatment. Some interesting comments about how to comply with GDPR when you're holding diversity data. I'll come back to that in a little more detail later, because that is something I can help you with. Extended outcome with respect, with expectation of feedback on where tenant views have influenced the landlord. So it isn't enough now to say, thank you for sending us your views. They have been noted. There's now a positive requirement that the landlord is going to be able to say, here is what we are now doing differently because of the tenant feedback that we obtained. So a little bit like you might find, certainly I've seen them in the foyers of gyms, that sort of thing. You said this, we did that. The sort of, here's something we've changed, and we can link it back to responses to a survey or a particular complaint that we've had. So essentially, the tenants need to be getting some credit for the change that they have assisted in producing. And requirements specifically for information about tenant rights and landlord requirements and the complaints process. So we've been doing some work with the RPs about what does the publication scheme look like for compliance with this standard. What exactly should you be putting out there? How often should you be publishing? How much detail do you have to go into? And we'll come to that a little bit later in the code. Again, it's largely up to you, but you've got to be satisfied that you're meeting the requirements. So next standard to take a look at is the neighbourhood and community standard. Again, lots of reference here to the safety of shared spaces. One of the key feedback themes that emerged from the consultation, and I think this definitely came from the registered providers and local authorities, was a strand of, if these are shared spaces, if these are third-party owned property, how can it be our responsibility to resolve what's happening in those areas? We don't have occupiers liability. We're not the owner of the land. We can't exclude people from it. The idea seems to be that it's about collaborative working and taking reasonable steps. So it isn't an absolute obligation on the landlord to resolve a problem that's in a shared space for which it isn't responsible. However, it should be taking steps to do something about it. The local corporation requirement has survived some suggestions that it might be a bit too heavy. Specific references have now been added to hate incidents as well as ASB. And this is much more in Paul's wheelhouse than mine. I could imagine a situation, you could have a hate incident that might not be ASB. Maybe you can certainly have ASB that isn't a hate incident. So specifically, that extra category is in there. And there is that requirement to be having a policy relating to domestic abuse, identifying that as separate to ASB and making clear where your organisation stands and how it proposes to deal with it. And that's picked up later in the code. And in the tenancy standard, there's some helpful clarification on a couple of points, that the requirement on the landlord is to seek to allocate suitably designed or adapted housing and to seek to address under-occupation and overcrowding. It's been a very valid point made by landlords in response to the consultation. You can't actually resolve under-occupation and overcrowding just because you want to. You can certainly try to, and you should try, but as I found in a number of cases in which we've been involved, if people don't want to move out of the house they're in and they're not in breach of their tenancy, even if it would be more suitable for somebody else, you can't necessarily make the house available for them. So you can seek to, but you don't absolutely have to. The removal of the requirement to minimize time between lets, so shortening void periods as much as you can, that stays. That's no longer in the standard. There's some discussion from the regulator as to whether it might have been put back in or not. And the view is that it's for each RP to balance up how much rental income it wants to go without during the void period versus making suitable use of that void to upgrade the property, address any health and safety concerns, potentially address adaptations, and having that property out of circulation for a little bit longer might mean, for example, you can allocate somebody a suitably adopted property because you've adopted it while it was empty. If you simply rush every property straight back into general needs, you might lose the opportunity to meet some of those other requirements. So the regulator is saying, it's up to you. You don't have to get somebody in that void as fast as humanly possible. You may have a better plan. And again, so long as you've got that plan and you understand how it works, that's not a problem. And the content about mutual exchange, that's the government's requirement that it be included. There were suggestions it be changed. The regulator is leaving it be. It's following orders on this one. So what we've then got is the new Consumer Standards Code of Practice. So this is all new. This hasn't been around before. And it's worth clarifying that, number one, the regulator isn't changing its status. So it's neither enforceable, nor is the regulator prepared to say it's just guidance, you don't have to do what it says. Because if you absolutely don't do what it says, it's evident the regulator is going to say, why didn't you go along with what we suggested in the code? It represents a generally applicable good idea. You may have a good reason why it didn't apply to you, but I think you would need one if you're going to say, might work for others, but doesn't work for us. And coming back to my point about procurement, where the landlord's services have been contracted out, responsibility to the tenant under the standards stays with the landlord. So it's a bit like TUPE. You can't make it somebody else's problem through contract, and you certainly can't make it somebody else's problem just by wanting it to be that way. So it stays with you. So you need to have a robust contractual mechanism for making sure that the standards are being maintained in relation to those landlord services where you have outsourced them. So what does the Code of Practice say about safety and quality? Well, there's a requirement there be a sufficiently detailed understanding of stock. And the suggestion that it could be up to 5 years, but it really ought to be less than that in your rolling program if you've identified any risk features, any known problems, any particular link to vulnerability, anything that suggests it should be more frequently than every 5 years, then it should be more frequent. A range of factors that you can put together to decide when there should be a more frequent inspection. And that, I think, is a suggestion you might want to do a bit of data matching. So firstly, do you know you've got a particular kind of property that has a particular kind of problem? And is there an intersection with a particular subset of your tenants who happen to be in that kind of property, where the combination of the two creates a heightened level of risk. So nobody will be planning to have the more vulnerable tenants in the more problematic building, but that could happen sometimes. And if both of those things are in play, do you really want to leave it 5 years before you go back and check again? That's where the code of practice has gone with this. There is a suggestion that RP should consider opportunities where the inside of a home can be assessed, such as, for example, the gas safety check. Now, this strikes me as on the outer edge of optimistic. I have had a lot of discussions in the course of doing procurement about, can we build in a duty on the gas safety contractor while it's in there doing the gas safety to have a bit of a look around the rest of the house, report back to us on whether they think there's any risk, any condition problems, any disrepair. Well, the first problem you've got is that gas fitter is a gas fitter, not a social worker, not a structural surveyor, none of those things. So realistically, what are you expecting that person to find? And secondly, bearing in mind, we have to deal with, I think I can probably safely say hundreds, Paul, if not thousands, of gas access injunctions every year. So there are tenants who don't want to let the gas servicing operative into the house, even if it could save their lives. And that is not going to necessarily be assisted by that person then having a bit of a poke around and looking in their kitchen cupboards to see if they've got too much ultra-processed food in the house. So do be careful where you go with this. It is an opportunity, and if the glaringly obvious is there to be seen, then this could be an opportunity to find it. But if you're going to build surveying and welfare checks into your gas servicing, I would expect the cost of that gas servicing contract to go up, because it may well be necessary to send more than one person, because if you're in the cupboard fixing the boiler, you're not looking around the rest of the house. So I wouldn't necessarily hang your entire compliance on this particular option. It's important to be looking at the context of the needs of individual tenants that are in the houses. So it won't be the same experience living in that house for every different person. And as with many elements of this code of practice, you didn't need me to tell you that, and I don't think you needed the RSH to tell you that either. However, it is a key theme that's running through this, and definitely through what we've heard from the Ombudsman. So proactively identify risks to tenants. So not a matter of waiting to be informed, not necessarily waiting for the disrepair, waiting for the complaint. If you know, and certainly I've done this with a number of clients, we found a problem in a particular house. How many houses like that do we have? Is that a feature that we think is likely to be in other houses? And if so, how many of them? Because do we need to get out and start looking at the other ones if what we've just seen is the first instance of what, with the benefit of hindsight, we might have seen coming in other places? That's fair enough. So again, references there to communal areas, and picking up a lot actually later on from what the Ombudsman has to say about adaptations. There's a clear thrust in the code of practice here that if a tenant's looking for an adaptation and the landlord doesn't offer an adaptation service or doesn't do the particular adaptation that the tenant is looking for, that is not a reason to say no. That is merely the start of a process in which the landlord goes and finds a way to assist that tenant, even if it can't do that itself. So quite a bit on this next slide. This is what the code of practice has to say about transparency, influence, and accountability. So this is the standard with the biggest change in it. So quite a lot to get into here. That reference there to diverse needs, I interpret this as effectively a requirement for RPs to go looking for the potential for indirect discrimination. And just to recap, indirect discrimination is where an organization has an objective requirement or policy or process, and without meaning to discriminate against a particular group, it does so in fact because that policy or that process works significantly worse for a particular group. So that's indirect discrimination. Nobody's saying you're out there victimizing any particular group, and it may feel like a really good idea, but look out for the potential knock-on. So it is fair to say, I don't think I'm stealing Paul's thunder here to say that the Ombudsman has suggested at various points in the Spotlight report It's no use to use a website. It's no use to use email. And it's also no use to send people letters. All of these are unsuitable and unsatisfactory means of communication, which leaves possibly semaphore, pirate radio, or whatever other methods you might be thinking about. But it is a fair point to suggest that if you hang your hat on only one method of communication, it isn't going to suit everyone. We have had one client who's noticed the cost of post going up and is thinking about, can we go completely paperless with all of our tenants? And in some circumstances, just no, as a matter of law. In other circumstances, actually, is that going to work? Will all of your tenants, in fact, be capable of receiving that email? It's possibly over-optimistic to think the post bill is going down to zero. It's fair to think you might be able to make a very significant dent in it and spend the money on something else, but that blanket solution probably won't fly. And it's a good example of, seems like a great idea on day one, but if you actually play it out across how it might work in the real world, might not be as successful as you were hoping. Genuine consideration of tenants' views at the heart of decision-making about services, and they're also strategies, policies as well. So not just, we've set our repair policy, we're now going to have a tenant consultation about when would you like your appointments. The suggestion here is, before you set your repairs and asset management strategy, you should be having tenant consultation at that point. So it isn't a question of, we know what's most important, now how would you like us to do it? It's actually collectively, co-production being the buzzword that you can see in the standards and in the Ombudsman statement. What do we collectively think the strategy should be? What are the most important things? And if you're going to have consultation, it's got to be meaningful. And the specific example is given there of changes of landlord where property is tenanted, particularly going to a non-RP landlord. And I have worked on one of these cases where there was a question of, did the organisation need to bring itself to the attention of the regulator because it was proposing a stock transfer to a charitable housing provider, but it wasn't a registered provider. So the consultation bigged up, said a lot about the charitable status, the large resource base of the new landlord. That was fine. But what it didn't say was, we have to bring to your attention, it's not a registered provider. It is outside the regulatory framework. You will not have the rights of an RP tenant. So there were two sides to the story, and not both sides weren't being put forward with an equal level of prominence. So if you're doing the consultation, do be careful not to spin it even accidentally. You've got to lay out both sides, let people come back to you with their feedback. I think we've got something popping in the Q&A. The guidance does refer specifically to tenants, but there is quite a wide range of things held within the term tenant. I think their use of the word tenant is generally to denote occupiers, because there's certainly coming up later on reference in the codes of practice to the use of licenses. So if the use of licenses is covered by the code, then my understanding will be that the regulator thinks it's also covered by the rest of the standards as well. But certainly we do a lot of temporary housing work, and license agreements are often the right solution. And I don't read the code as saying you shouldn't do them anymore. So hopefully that is an answer to that question. Do please come back if there's more to it. So the last point on the accountability side of this, in terms of self-referral, if the organisation is unsure whether an issue is material, it should self-report to the regulator. So here's my little bit of advice on that. Don't be unsure. Be sure that it isn't reportable right up to the point when you change your mind and become sure that it is. Because if you're unsure as to whether it's material or not, I wouldn't be reporting on that basis ideally, because that would suggest I didn't understand fully what was going on. So if you're not in a position to understand the materiality of the problem, I would tread a little bit carefully, because given what's in these standards and the information and knowledge you're supposed to be gaining, being unsure as to the materiality of the effect might be a little bit of an admission. If in doubt, Good idea to engage with the regulator, certainly if you know that's the direction it's going in. If you've seen enough and it's only going to get worse, go early, because the regulator will give you credit for that. On the other hand, if it's very, very early days and we don't know whether we even need to report yet, I think it might be a while to take a breath and see what you find out maybe the following day. Give yourself a little bit of time to think about it. So then the neighbourhood and community standard, lots of work about shared spaces there, safety lighting, fly tipping, both of which are local authority obligations, environmental health, highways agency, but something that you're required by the code of practice to try to help do something about. What exactly there is that you can do, maybe you can report it, maybe you can give the local authority a bit more hassle than an individual tenant could do. There's a reference there particularly to reducing hate incidents and joint initiatives with appropriate partners. And it doesn't go a lot further into saying what an appropriate partner looks like. It certainly does give an example of what those initiatives might be. And there's a lot there, I think, that's going on in the charity sector. Certainly we've been involved in some charities doing diversion programs, awareness raising, that sort of thing. So there are organizations out there with which you could join up. Quickly pick out some of the more important things here. Diverse needs around the reporting of ASB as well as the impact of ASB. And I'm sure that's something Paul's going to be picking up at a later stage. If you've got somebody whose experience of ASB is made even worse by the fact that they can't work your reporting system, then their experience is considerably more negative even than it should have been. And again, looking at the specific needs of tenants and the issues around domestic abuse, that's all a part of the heightened requirement for awareness. So then finally, the tenancy standard, what does the code of practice say about that? We've got allocations where there's a requirement to clearly set out the decision-making criteria. Now, you should have a pretty clear allocations policy. The clearer, the better. It may be that you can explain a little bit about how that is applied. And speaking as somebody who is at present in the middle of a school admissions experience, let's just say that, yes, there are criteria, but I do have some pretty serious questions as to how they've been applied, particularly when they've produced a very unexpected outcome. So it may be that you can help people to understand a little bit more about what's going on, and certainly put yourself in their shoes, see what the information looks like from their perspective. There's some suggestions as to what you might do to support people having more sustainable tenancies. And that is information and advice with money management, energy saving, and helping vulnerable tenants to live independently, including those with mental health issues or alcohol dependency or drug use. So do be careful with this and don't fall into what I call virtuous mission creep. There's a clear imperative to want to help, but do be careful. Money management advice can very readily turn into regulated consumer credit activity, and that's enforceable by the FCA. And debt counselling or debt adjusting or credit broking are all things that require what in the common parlance is called a consumer credit license. So do be careful not to step on part of that world of regulatory pain by being too keen to help. And equally, if what people need is adult social care and medical support, then it may be the best thing you can do is help them find it rather than necessarily attempting to provide it. It expects an awful lot of your support teams to be able to do all of these things for tenants at the same time, and hugely over expecting what RPs can deliver is not a new thing. What we've got here is potentially a slightly different statement of it. So take it on board, but be advised, and I think it's a reasonable point to make back to the regulator or the ombudsman if the need arises, there is only so much we can actually do. Watch out for appropriate use of licenses, which picks up on the point hopefully we picked in the question a second or two ago about licenses. And be careful about using fixed terms under 5 years, specifically where you will be using them on a blanket approach for everybody in this group of tenants gets it, or everybody in this area gets it. So even if you have a plan for what you want to do in a particular estate or a particular neighborhood, do be careful of applying a one-size-fits-all, because the suggestion here is that the tenancy standard is not looking for that. And finally, in terms of your vulnerability policy, you need to be aware of how that is taking into effect the needs of vulnerable households. And again, coming to that in more detail with Paul. So I looked for content about what happens when a regulator is stepping up, because the RSH is clearly stepping up its enforcement powers, stepping up its interest in the consumer standards. So this turned out to be quite an instructive diagram, in that it's complicated. It's got a lot of different components in it, all of which can be said for the consumer standards. You only really know how it's going to work when you switch it on, and that's happening on Monday. And it could potentially deliver a nasty shock if you get hold of the wrong bit of it. So actually, this circuit diagram is not a bad metaphor for the 2024 version of regulating the standards. What are the key components? Which are the bits we definitely don't want to be putting our fingers on? So quick recap of the regulator's statement of its role and approach. Private RPs, all 7 standards, local authority RPs, red standard, and the 4 consumer standards. So rewind to the start, all consumer standards for everybody all the time. It's a risk-based approach, particularly looking at those risks there. It's focused on the delivery of outcomes. So the language all the way through it is a risk that the landlord will fail to deliver the outcomes set in the standards. So it always links back to the standards. That's what it's all about. And under the inspections section, the new model structure for programmed inspections includes a lot more content now on transparency, influence, and accountability, as you would expect, because of the new prominence that's getting as part of the revised consumer standards. Here's the interesting bit. The new C grade, the new C rating. So it used to be G and V, it's now G, V, and C. So there is a new consumer standard rating. In theory, should only be given as a result of a programmed inspection. So the regulators had a chance to look across the piece. However, not so. And serious failings may produce a regulatory judgment and early application of a C grading. So this could be happening to you earlier than you might expect. My apologies. I will now click. I'll move my mouse enough to click on the question that's popped up. Perfect. Coming back to that GDPR point in a moment or two. So please bear with me. I'm coming to that. As the data protection officer for Forbes Solicitors, I spotted that bit and I have been giving it some thought. So coming to that very soon. The key thing here is that a C1 grading is not the same as G1 or V1. And that's why the quote's down there in the bottom left. You cannot please all of the people all of the time. A C1 grading assumes you will still have to make improvements. If you're at G1 or V1, you're as good as it gets. If you're at C1, you're not allowed to rest on your laurels. You've got to keep going. So if C1 isn't as good as V1 and G1, down at the bottom level, C4 is arguably worse than G4 or V4. It relates to fundamental change being required in the organization in order for the landlord to be able to deliver the outcomes of the standards. So fundamental change sounds fairly painful, and it sounds a lot like regulatory enforcement. And I think if you get as far as C4, that is where you are going. Interim gradings are an interesting thing where you've got organizations merging or undergoing serious change. If everybody's up at standard 1, that's fine. If anybody is at a 2, then the merged organization is automatically dropped to a 2. The regulator is not prepared to assume that the higher rated organization will improve the lower rated organization. The starting assumption is lowest common denominator. The merged organization will come down to the lower level and will then have to justify going back up again. So with apologies for the spoiler that I managed earlier on, here's the illustration. If you see anything with a C4 on it, run and keep going, because it's about to come down around your ears. That is broadly what the regulator is saying if it gets to that. So C4 for a reason, handle with extreme caution. So looking then quickly at what happens between programmed inspections, lots of references to data quality, and that has been an issue in sector risk assessments. Tenant satisfaction measures, publications and reporting. Regulatory engagement will follow if there's a problem with the data quality, or you have outlier type statistics, or it appears that there's a serious risk. So if you're attracting an awful lot of complaints, even if you're resolving them, that's going to mark you out as, why have you got so many more complaints than everybody else? The review of the TSM data alone will not change your C grade. That should, in theory, be the broader spectrum inspection, at least once you get round to one. Factors for assessing regulatory issues. I'll quickly pick up this point at the bottom. Examples of impacts on tenants specifically include what happens if you fail to involve and consult the tenants, and what happens if they receive unfair or discriminatory treatment. So it's not just about health and safety impacts. It's not just about financial impacts. It is an impact that the regulator will take very seriously if tenants have lost the opportunity to influence your policy. Next issue is how the regulator deals with serious failures. This is where we were hoping we might find something to tell us what happens now the harm standard's been removed. As I read it, it's very much the same wording as it was before, but now without the harm test in play to clarify when there's going to be enforcement and when there isn't. So there'll have to be material failing, and it will then come down to how serious that failing is. And as we mentioned in our last session, talking about the guidance on enforcement, that looks a lot like the harm test, but put another way. And I might agree with you, it does look a lot like that, but it can't be exactly the same thing because the Social Housing Regulation Act abolished the harm test. So as lawyers unfortunately often say, we're going to have to wait and see some cases coming through, or you can come along to our forthcoming event on the 19th of April and ask the RSH's Director of Regulatory Engagement herself, because our plan is to get her in a room and see if we can get a little bit more explanation. So keep an eye out for that. I'll mention it more near the end of the session. It remains the case that if the landlord has the will to put things right and is perceived as having the capability, enforcement action should not follow. So the good news is you will still be expected to sort things out for yourself, and most cases be given an opportunity, and lots of reference here to voluntary undertakings, which is where you explain how you're going to make it right, and the regulator says, okay, then do what you said. And certainly voluntary undertakings are a condition precedent to some of the regulatory powers. So the regulator shouldn't go in particularly heavy without first giving you the opportunity to at least propose a voluntary undertaking and try to fix it yourself. So having gone through that at some speed and pinched a little bit of Paul's time, so apologies to that, Paul, I will hand over to Paul's in practice session, and now you can get into how this makes a difference in the real world.
Thanks, Dan. So can you just move on to the next slide? Yeah. So what I was going to talk about today is how perhaps some of this stuff is going to work for you in practice. We've had this very sort of high level overview there from Dan about the various government structures and the regulatory regime you're going to be operating under. But for those of you who don't know me, my background is not in governance like Dan's. My background is in housing management. So we're street level at housing management. We're dealing with those issues that you're facing with your tenants, and that gives us a little bit of insight into how these things actually play out sometimes. So as Dan says, we've got this new regime. I picked out these sort of 4 elements of it. We've got the new consumer standards. What is it? What are the new standards that you're being held to? We've got this new enforcement regime. But for me, what I think is going to be really important at the ground level, it's going to be the code of guidance as well, and it's going to be a new role for the housing ombudsman. I've got a bit of a working theory with this. I think you could read the new standards and think, do you know what? There's, we're getting more closely regulated than we were before, but it's it's not too bad. We could live with that maybe. But my view is that to really appreciate the scale of the changes coming, you've got to read them with the code of guidance and understanding the beefed up role of the housing ombudsman in this. And I think when you do that, it's not that it's a sort of a different regime, but it's much sharper, much more pointy, and therefore much more painful if you get on the wrong end of it. Dan, if you could just move along to the next slide there. So yeah, really here we're sort of just repeating what Dan said earlier. There's a new code of practice. There's always been a code of practice, I think, for the regulator, but previously it was about the economic standards. The regulator did not have the power to issue a code of guidance on the consumer standards, even if it wanted to. One of the things the Social Housing Regulation Act is changing is that the regulator can now issue that code of guidance about the consumer standards, and it's done that, and we've got that document, and that's available to us now. And what's important is, again, it's not exactly legal guidance, but the Act says that the regulator may have regard to the code when it's considering whether the standards have been met. And I think that's really important, because generally speaking, the code of practice is going to be so I've called it a code of guidance on this slide. Apologies for that. The code of practice is going to be a lot more specific than the standards themselves. So they're putting a lot of meat on the bone, I think. And even though, and because it's something that the regulator may have regard to, and because it's quite specific, I think there's a number of occasions where you're really going to, it's going to be really difficult to see how you could possibly meet the consumer standards if you haven't basically done what the code says. So there's a number of, I think, expectations in the code, and you would basically be, I think, be well advised to treat that as if it was almost in the consumer standards themselves, really. And one of the examples we'll come to is dealing with vulnerable tenants or tenants with diverse needs. So Dan, if you can just move along to the next slide for us. We've also got, as Dan was saying earlier, we've now got this, it was always a co-regulatory approach. Maybe now it's best described as a tri-regulatory approach, because the housing ombudsman is on the scene. And I mean, of course, the housing ombudsman has always been on the scene, but he's got this slightly enhanced role here. So this is how the government is putting it on their fact sheet. It makes it clear the ombudsman may refer complaints to the regulator where it suspects evidence of systemic failure. So we're not talking about, the odd complaint here. That's necessarily going to happen. Indeed, as Dan was saying, even if you get a C1 grading, that's not because you haven't got any complaints. There's always going to be complaints. But where that becomes, where the ombudsman starts to think, actually, these are not just isolated incidents, there's evidence of systemic failure here, then the ombudsman can refer those complaints to the regulator, and the regulator then considers all the information that's received through the complaints and deferrals to determine whether there's been a wider failing within the landlord's systems or processes. That means the landlord has failed to meet the regulator's standards. So in other words, if you find yourself in trouble with the housing ombudsman a little too regularly, the housing ombudsman may conclude, well, actually, there's a deeper problem here. There's a systemic failure, and it can report you to the regulator, and then the regulator will be considering whether there's a breach of the consumer standards more generally. So again, if you can just move to the next slide. Dan. Yeah, so we've got this. I think this is really important. The Housing Ombudsman's produced this report from January of this year. It's this spotlight on attitudes, respects and rights. You might have remembered there was a previous report on damp and mold, which is very influential. I think this is just to some extent, the Housing Ombudsman is reactive. It's dealing with the complaints that it gets through the door, but from time to time, it does sort of pick out these themes. And I think that tells you something about what the what's across its desk, what the issues that are really engaging it at the moment, and kind of the things that it gives you an idea how it might be dealing with some of these, and what you need to be doing, and to avoid a finding of maladministration. So I would encourage everybody here, to have a look at this spotlight on attitudes, respects and rights. But if there is one phrase which comes out of that, I think actually, Dan, you're doing this webinar on with Darren about it on Wednesday, aren't you? So yeah, if you're not signed up to that already, get signed up to it. But if there's one phrase which comes out of that, it's this: it's general needs does not mean no needs. I think that's going to be the sort of the guiding light for the Ombudsman for the foreseeable future. That's something that they've got a very sharp focus on at the moment. This idea that I mean, yes, of course, there's supported housing separate to general needs, but if you have a look at the English Housing Survey, etc., it's very rapidly apparent that actually a fairly high proportion, I mean, and you'll know this from your own experience, a reasonably high proportion of tenants in social housing in general needs still have some kind of needs. They may be vulnerable in some respect. And the situation's only going to get more acute over time. There's social studies, projections of what the typical social housing tenant is going to look like over the next 5-10 years. Suggest that they're probably going to be poorer, and they're probably going to be older, and they're more likely to suffer from mental health issues. So this idea that general needs doesn't mean no needs is only going to become truer going forward over the next 5 to 10 years, and that's something that obviously you're going to need to be planning for as an organization. And what you really do get coming through from the Housing Ombudsman is that they've got a real focus on vulnerability here, and what we get is this very wide definition of vulnerable being used by the Housing Ombudsman. They're in that document, they're drawing from a number of different legal contexts. They draw on the definition of vulnerable in the Housing Act 1996 for homelessness. They draw on the threshold for a safeguarding referral in the Care Act, and what they actually come up with is a definition which I think goes beyond all of those. And that's right to some extent. You wouldn't want to equate being vulnerable with requiring a safeguarding referral, because quite clearly somebody could be vulnerable without necessarily meeting that threshold. The bottom line is that the Housing Ombudsman is working to a very wide definition of vulnerable, and it's something they're going to really have their eye on in the foreseeable future. So it's going to be something that you're going to need to be really careful with when you're dealing. And what I want to look at in the next couple of slides is kind of how that is picked up on in the new consumer standards. So Dan, if you can just move the slide on there. Yeah, so this next section here is about dealing with diverse needs. I've picked this up because this is something, as well as picking up on that stuff from the Ombudsman about dealing with vulnerable people, dealing with diverse needs is something which is going to cut across all your areas of practice. It's a required outcome of the Transparency, Involvement and Accountability Standard. It says that in relation to the housing and landlord services they provide, registered providers must take action to deliver fair and equitable outcomes for tenants and, where relevant, prospective tenants. And again, if you can just move on to the next slide, Dan. And as well as that, there's a number of specific expectations where the regulator sets where the regulator sets required outcomes. It sets specific expectations as well. And it says that you must use relevant information and data to understand the diverse needs of tenants, including those arising from protected characteristics, language barriers and additional support needs, and assess whether their housing and landlord services deliver fair and equitable outcomes for tenants. You must ensure communication with and information for tenants is clear, accessible, relevant, timely, and appropriate to the diverse needs of tenants. So that's picking up on what Dan was saying earlier about communication methods. If I can just ask you to move to the next slide, Dan. So this is carrying on with more specific expectations. You've got to ensure that your services are accessible, that that accessibility is published, and that includes supporting tenants and prospective tenants to use online landlord services if required. That's really important, because one of the things that Ombudsman's picking up on in its report is this statistic from the housing survey, which suggests that 17% of households don't have internet access at home. So, but there's a risk that we see the availability of online services, being able to move things to online as a cost-cutting measure. For example, you know, the price of a first-class stamp has just gone up. I think it's about £1.35 now. So the more stuff you can move to online, you know, you might be thinking yourself, well, you know, we're under financial pressure here. Where can we make those savings? Well, move to online. But be aware that a significant proportion of your tenants will not necessarily have that access, and it's more likely to be that cohort of very vulnerable people who can end up being excluded in that way. If you can just move to the next slide there, Dan. Yeah, so looking at so rather than simply looking at the standards themselves, I've just tried to pull out a few ideas about what this concept of diverse needs actually means, because there's no definition of diverse needs either in the standard or the Code of Guidance themselves. There are, however, lots of examples of it. So we see communications, which we've just seen: clear, accessible, relevant, timely, appropriate. There can be language barriers that can give rise to a diverse need, that need to support tenants to use online services. A need for a representative or an advocate could be a diverse need. In terms of repairs, older tenants or disabled tenants may need to have their repair prioritized because it's having a disproportionate impact on them. Also, there may be special measures that are needed to support victims of domestic abuse or antisocial behavior. So, for example, one of the examples given is, you know, safety measures. You know, a tenant who is a victim of antisocial behavior or domestic abuse may need a better quality lock fitting, for example, or better lighting installed in the communal area outside their home. The diverse needs can also emerge in the context of needing accessible support, so tenants can engage with, influence and scrutinize the landlord's policies. Again, it's really one of the themes that's coming out of this is that it's not just about treating your tenants better. The new consumer standards are also about involving your tenants in the decision-making process in the first place. And one of the issues here is, well, you know, you may well have an entire cohort of tenants who are excluded for that for some reason. So there is this diverse need there for support, so people can fully engage with that. And finally, the other example I've been able to find is something that Dan was referring to earlier. There can be barriers to reporting antisocial behaviour and hate incidents. One of those barriers might be electronic, which we've talked about. You know, tenants don't necessarily have access to the internet, don't have access to web portals, don't necessarily, or don't have that knowledge to do so. But there can be other barriers as well. There are people are being victimized and exploited, and you know, they don't know how to reach out. Those sort of cuckooing type situations where the tenant's been disempowered from reaching out and making that report and telling the landlord about the problems that they're facing. That's some examples of the different sort of diverse needs which you find in the Code of Guidance. If you just move to the next slide there, Dan, thank you. Yeah. So this is a reminder of the protected characteristics in the Equality Act 2010. Hopefully you've all seen these before. We've got age, disability, gender reassignment, and so forth. We've already seen from some of the examples we've given how a diverse need might arise out of a protected characteristic, out of, we talked about repairs for older people, prioritising repairs for older people, or how a disability might mean that someone isn't able to access or engage with services in quite the same way. If you just move on to the next slide there, Dan. But I think there's more to it than that. So although diverse needs are going to be related to protected characteristics, they don't require a protected characteristic, and you can easily see how there's going to be people who have needs that other tenants don't, and yet they do not arise out of a protected characteristic. So for example, someone could be facing digital exclusion. They might not have the internet at home because they can't afford it. And poverty is not a protected characteristic. Now, it may well be that the poverty is caused by a protected characteristic. It's well understood that people with disabilities have a more difficult time accessing the workforce sometimes, but it's not necessarily the case. So there is more to diverse needs than just protected characteristics going on here. For example, the other one we can talk about is being a victim of antisocial behaviour. You don't need any kind of protected characteristic to be a victim of ASB. You just have to get on the wrong side of your neighbour for some reason, or possibly no reason at all. So for me, the point I'm trying to make with this is that I think it's important that we avoid seeing diverse needs as something which comes out of the Equality Act. It's definitely coming from a similar place to the Equality Act. It's definitely working alongside with the Equality Act, but it is not entirely coming out of the Equality Act. There are people with diverse needs who do not have relevant protected characteristics. That seems clear to me. And moreover, I think it's not just about vulnerability or harm or detriment as well. I think it comes from, it's more of a fairness and respect agenda than simply, what's wrong with, why do we have to provide diverse needs? Well, the answer is not because otherwise someone could be at risk of harm, although clearly somebody could be at risk of harm if they have a need which is not met. I think it's as much about dealing respectfully with that person. So for example, you could have you could have a bilingual community. You could have a community where two languages are spoken, and one of those languages might be English, but somebody from that community might say, well, although I can understand English, actually my main language is something else, and I would like you to provide that to communicate to me in that language. So even though there would be no harm to that person, if you correspond with them in English because they understand English, there may well be an issue about whether you're showing respect to their culture, or to if you don't do that. So it's a bit of a I think there's a little there's more to this going on than simply vulnerability, harm, detriment. It's about fairness and respect, and you can see that phrase, fair and equitable outcomes in the standards that we were looking at a few minutes ago. And to this extent, I think diverse needs might actually be a better term than vulnerability in some way, because it's telling you practically what it's telling you what the person needs, not what the person is, but what the consequence, what's the consequence of someone's being vulnerable? Well, they need something. They need something to, to make good for that. And somebody might need something which, maybe they're not at direct harm if they don't get it, but nonetheless, it's important to them for reasons of fairness and respect. So we just move on to the next slide, please, Dan. Yeah, what I'm doing here is this is just copied and pasted from the code of guidance, but I'm just highlighting. I'm not going to read all this out because it is just in the code itself, but I am going to try and pull out what I think are some of the important ideas here. And firstly, when we're talking about diverse needs, this consideration should be integral to the culture of the organization. And I think that is the only way to avoid any problems with the ombudsman or the regulator on this. I'm a solicitor. We do a lot of litigation. One of the things we have to do in litigation, if the case gets so far, we have to do disclosure. We have to make available to the other side all copies of relevant information to the case. And any solicitor who's worked on this will tell you there is the risk of finding something embarrassing in your client's own files that can undermine your case. And sometimes what you're looking at is insensitive remarks about a tenant. And so there's a real, there is, unfortunately, occasions where really, silly things get put down in emails, and so, and I think that does go to the culture of the organisation to some degree. Certainly, the organisation should have a culture of stamping this out and retraining it when it is. So this is going to be, I think, this is going to be really important going forward. It's about embedding this understanding of diverse needs in the organisation itself. It recommends regular equality, diversity and inclusion training. Again, I'm sure there's a lot of you here who feel like you've had an awful lot of that already, but nonetheless, there might be more coming down the line for you. And this last thing that I've underlined here, I think, is really important. It says you've got to carry out work to understand the barriers. So that's what that's telling us, is that you've got to be proactive about this stuff. You're going to have to work to understand what the issues are within your organization. So a couple of slides ago, we saw, the regulator give us various examples of where there might be diverse needs, but that's not going to be enough. You're going to need to actively carry out work to understand where the diverse needs emerge, where the barriers are, and how you can remove those barriers. Dan, if you can just move on to the next slide, please. Yeah, this is next slide here. This tells us that you've got to have robust information. So you can deliver fair and equitable outcomes, and this is going to be information about protected characteristics and support and communication needs. But again, look what it says there. It says include, but not be limited to, relevant information on protected characteristics. So that's kind of that for me is supporting the idea I was advancing a few slides ago, where I said that, you know, protected characteristics is important to this, but it's not the whole picture. And the regulator clearly agrees here, because they've referred to it at paragraph 32. For me, what does robust mean? You see the word robust a couple of occasions in the standards and in the code of guidance. Seems to mean three things. Your information's got to be accurate. So when I've seen records where the landlord understands some of a person's disabilities, issues, vulnerabilities, but not all of them, it should be up to date. So I think we can say that the days where, you know, all the landlord knows about a person's vulnerabilities is what's on the tenancy sign-up sheet, those days are long gone, and it should be detailed as well. And again, I've seen cases where we get the tenancy file and it says, well, the tenant is vulnerable, but nothing more. And again, that's not, you know, that for me is not a basis on which you could make an informed decision about how to properly treat this person fairly and with respect. The only thing I'd want to pick up on this slide is where it says fair and equitable outcomes. And again, I think that feeds into this thesis I was advancing a few slides back, where we say it's not simply about, you know, avoiding harm to people. It's about treating them fairly and with respect. Dan, if you could just move on to the next slide. Yeah, so this was this is a paragraph where the regulator is engaging with that question. Well, how do you know, how do you stay on top of what diverse needs your tenants have got? It's quite clear that, you know, it needs to be kept up to date, and you're going to need to use a range of methods to collect this. And again, there's a couple of suggestions in the code of guidance, in the standards, and even in the Housing Ombudsman's documents. So there's obviously the tenancy sign up at the start of the tenancy, but you've got to be aware there that, you know, if you simply put a form in front of a tenant and ask them to fill it in, well, not all tenants recognise their own vulnerabilities sometimes, or they don't want to put them on a form. So you may need to be thinking about other ways of eliciting that information from them at the outset. Obviously, you've got your housing officer's knowledge of the residents. That's a huge resource available to you. You've got tenancy audits. You know, just a regular check-in with your tenant and the tenancy. See how they're doing, see if there's anything they want to tell you about, you know, whatever it is their experience. But one of the things that really comes through from the Housing Ombudsman's report is this idea that vulnerability or needs can be transitory. One of the examples that the Ombudsman gives is grief. You know, and grief is a transient state. You know, hopefully people, you know, get over it after an amount of time, but for a period, they're going to be vulnerable, then they're going to have needs that they don't have at other times of their life. But, you know, you wouldn't know that at the start of a tenancy. It's something that's going to come up from time to time, and you need to be aware of that as far as you possibly can. The last thing you can do is tenant events, and one of the examples the Ombudsman gives of good practice identifying needs is there's a housing association, he says, which holds, I think quite a few associations do this, holds a regular kind of summer fair, and they use that to get in front of their tenants and to be speaking to them, but, you know, the ones who perhaps don't engage through usual channels, and they can speak to them and try and build a picture of what their needs are and what their situation is at the moment. So you've got these different channels and these different methods which you can use to start to understand where your tenants are. So that's really what I wanted to say about this. I think it's really important as a sector. We have a deep understanding of what diverse needs are, and we perhaps move away a little bit from this notion that, you know, it's to do with protected characteristics. For example, it's more than that, and I think we have to understand that if we're truly going to embed that in our cultures as the regulator and the ombudsman suggests that we need to do. And it really is clear from what the ombudsman is saying is that, you know, if you're not on top of this stuff, then, you know, it is going to come back to bite you. And there's a I mean, we don't have time to go into it today, but there's a number of case studies in that ombudsman's report where they find maladministration and they find unfavorable treatment of tenants. And under this new regime, if you start getting a few of those complaints, well, at some point that's going to start to look like not isolated incidents, but look like a systemic failure, and potentially a referral to the regulator is forthcoming. So that's really where we are there. We've got this next slide here. I think that's the any questions slide, is it, Dan?
Yes, it is. And,
yeah.
I mean, I've had the opportunity, Paul, to take some notes while you've been speaking there, so I can now come in off the long run up and have a look at that GDPR question that we had from earlier. And it's really interesting what Paul was saying there. It comes up in the code and it comes up in the standard as well. You have to have all of this information about vulnerability, all of this information about diverse needs, up to and including and beyond protected characteristics. So we are way into special category personal data. So we've exited Regulation 6 of UK GDPR and gone safely into Regulation 9. We're looking at those more restricted justifications for processing without consent. And this is a hobby horse of mine and pretty much all GDPR advisors, so it isn't just me. There is in the Ombudsman's document a reference to there being very good practice on the part of a particular RP, which gets consent from its tenants to use information for the purpose of providing adaptations or accessibility or understanding their particular needs. The ICO's guidance, in fact, is that consent is the last thing you ever rely on. It's the first thing in the list and it's the last thing you use, because there are two things to know about consent under UK GDPR. Number one, it's as easy to take away as it is to give. And number two, it degrades over time. So you cannot assume you have consent to something that you had consent to at the instigation of a tenancy. And the key thing is consent can be withdrawn. So if you're relying solely on consent to hold somebody's vulnerability information and they withdraw that consent, you've got to delete it. And that can't be right. And that's the acid test I would always ask any client to consider in this situation. Can we actually manage without that information? Well, looking at this statement of your legal obligations as a registered provider, no, you can't manage without that. So it can't be consent-based. It's got to be based on an underlying obligation, the performance of a public function, legal obligation on the part of the landlord. So where you go about that is you address that not through a consent form, you address that through your privacy notice. You make it abundantly clear under Regulations 13 and 14, this is what we are going to do with your personal data. This is the kind of information that we need to have about you, and this is what we will do with it. And if you really want to push it, this is what we won't do with it. So we won't sell it to people. We won't use it to market things to you. We will use it to meet our legal obligations to modify our requirements. So it is also an interesting thing that Paul highlighted there, the different sources of the information. You could have your sign-up form, you could have surveys, you could have interactions. And this also feeds into the point that Paul made about the comments we sometimes find lying around in email systems. And certainly in my experience, in the free text box in the case management system or tenancy management system that you may have. We've certainly seen it in repairs. Is the repair done? Yes. What date did you do it? Tick. Do you have any other comments? Yeah, this tenant's a real pain. Did we need the free text? Or it might be important, but the question then is, can we get that training in place? And certainly when I do GDPR training, I do deliver more or less robust versions of that training based on the higher or lower level of awareness in the room about what is personal data and how easy it can be to get yourself and your organization in trouble with it. But remember that the requirement in the UK GDPR is technical and organizational measures to achieve compliance with the data protection principles. So technical measures can include access restrictions, and organizational measures can include training and enforcement of your policies. And we do see a tension sometimes between those two things, because you may have a wide open tenancy management system so that the repairs team can access everything there is to know about a tenant. The income team can access everything there is to know about that tenant. Somebody in your HR department can also access everything there is to know about that tenant. And in the third case, why is that necessary? Because that person works in HR, not in tenant-facing services. And equally, if you're going to be holding special category information, such as protected characteristic information, you need to be as sure as you can be that only the people with a need to know it can access it, and certainly only people with the appropriate level of authority can change it. There are, unfortunately, some problematic cases of people who make inappropriate use of service user information in a database, in particularly one police officer who I'm pleased to say is now serving a custodial sentence, who used the police national database instead of Tinder to find single women who'd had a traumatic experience, in order that he could target them as more likely to be persuaded to enter into a relationship with him. So you've got that information about people being vulnerable. They're having a difficult time. They're subject to domestic violence. You can't discharge your obligations in relation to domestic violence without having a record of whether somebody is at risk of it or suffering it. You've got to have that record. The question is, does everybody need to know? And it might be the case if you've got a red flag list of residents who might pose a risk to your colleagues or to visiting contractors. It may be you also have other coloured flags or other ways of making known to somebody who's going to their property, please be careful. There's an example, I think it's in the Ombudsman Spotlight report, of a domestic violence victim, and the contractor saw fit to send 4 guys around the house at the same time. So suddenly this person has gone from having a quiet house away from it to having 4 guys racketing around the house, generally invading her space. And in the circumstances, maybe that would have been better handled in a different way. That characteristic was known. It would have known why that person was living where she was living and how that came to be. Somebody hadn't put 2 and 2 together and said, maybe this should change how the contractor deals with them. So there's how you get the information, how you maintain its accuracy and its currency. And then there's clearing the way through the use of appropriate policies and privacy notices to making sure that you can use that information when you need to, without having to worry about, oh, do we have the person's permission to use this? In some situations, you might want to go back and ask, and in some situations, you might not. We did deal with a case where we actually waited for GDPR to come into effect in May 2018, because as soon as it did, we were able to make a referral to social services about a tenant who really needed that referral, but didn't want it to be made. And our view was, in the wording of the GDPR, it was easier to justify why we had felt the need to do that, because that person's situation was only getting worse. We'd exhausted as a landlord all the measures we could take, and it wasn't helping. It was so this person was going to end up on the wrong end of possession proceedings if something didn't change. And it's right there in the standards. What are you doing to assist people in maintaining sustainable tenancies? That is an expectation that you should fulfill. And sometimes you can't help everybody yourselves. So yeah, it is a big question. And I did promise Paul at the start I wouldn't turn this into a data protection in social housing presentation. So I did save it till the end, but hopefully that's useful. We have been looking at publication schemes in order to deal with the requirements of the standards and the code of practice. There is a suggestion in the code that you might publish your tenant satisfaction measures more frequently than otherwise required and in more granular detail. What it does go on to say that is, if you are going to do that, then you've got to keep presenting those statistics in a consistent manner. So if you're going to do more information, you need to be sure that you're not skewing how it appears and not, for example, only publishing the really good bits in further granular detail in order to drown out the less good information in other parts of the TSMs. So from data protection to statistics, it is a riot of excitement when you're considering how to imply this.
Dan, I think we've got another question, but I'm just going to make this observation quickly. There's a really good quote in the Housing Ombudsman's report about internal communications, and it says internal communications about residents should be factual, respectful, and avoid opinion or judgments. Where a culture exists which permits residents being described in such personal and emotive ways, that will undoubtedly be reflected in their direct communication and subsequently their relationship with residents. So what I'm taking from that is this idea that actually, if the Housing Ombudsman is coming across opinions, judgments, tenants being described in personal and emotive ways, well, that would create almost a presumption that actually there was something wrong with the culture of this organization. So it's really important that, you know, this is stamped out as far as possible. You're going to get in serious trouble with it. Yeah,
quite right. And again, as Paul said, it will come out in court disclosure. It'll come out in a subject access request. In any, you know, people don't need a solicitor to know how to make a subject access request. Lots of people know how to do that. Doesn't have to be formal, doesn't have to be in writing. You can't charge them a tenner for it. It's really easy to make one, and absolutely all kinds of stuff comes out. And I must remind everybody that deleting or altering information that is within a subject access request is a criminal offence under the Data Protection Act 2018. So if you put it in the system and thought better of it, you are in a very difficult position, because it really shouldn't have been there in the first place. And that's the only correct answer. But the other question we had just then was, what do you do about restricting access to this information and bearing in mind the need to have it and the potential harm that it can do in the wrong hands? Absolutely. And what we found is in organizations where there's no ability to restrict access within the tenancy management system, it then has got to come down to training. It's technical and organizational measures. Technical measures is kit, organizational measures is people. And if you have to do it, then you've got to say, this is our policy. This is a part of our data protection policy. This is where we stand. On inappropriate access of tenant information, inappropriate use of it will not be tolerated. It is an example of gross misconduct. Whoever works at the hospital where the Princess of Wales was being treated and was digging around in her medical records for no good end other than selling it to the press, I can't imagine that person works there, and I can't imagine that person is going to get another job in healthcare, because that is a career-ending error if you're going to make that kind of mistake. So what we have found is we have ended up having discussions about, can you do this in your system? Now, in our case management system, we can. We can set what's called a lock, and we can set that to a department, to an individual, to different combinations of people. So only the people who need to be able to open that file can open it. If your system doesn't let you do that, then it comes down to people making appropriate use of the system and not going looking where they shouldn't look. The system will most likely create an audit log of who has accessed the information. And it is surprising how effective it can be to make it known to your colleagues that if they access that record, they're going to leave a digital footprint. And if they can't explain what they were doing there, then that's going to be a bad day for them. That can often have quite a useful deterrent effect. People sometimes assume, well, all I did was look at it. I didn't change it. I didn't download it. I didn't print it. I didn't do anything. You did do something. You looked at it. You now know that information. Why did you need to look at it? If you imagine your digital records as if it were paper records, it's the equivalent of saying, what are you doing with your hand in my filing cabinet? What are you doing with your, you work in income department. What are you doing with your hand in the ASB cabinet? Why are you trying to find out about this? And it literally just is the digital equivalent of that. And if people understand that is not, that's not conduct you're going to put up with, the policy is clear. Regrettably, bad things may have to happen to somebody, but it is bearing in mind again, if you've got unauthorized access, that is a data breach. And you can report it to the Information Commissioner's Office, and you can say, this is the offence under Section 170 of the Data Protection Act. This is why the person's access was unauthorized. This is what we're doing about it. You're the prosecuting authority for this. Do you want to take it further? And they often will, because particularly if somebody's in a position of trust dealing with very sensitive information, the regulator will come down on that. And as Paul said, rightly so. So you've got to have that gate control over what's going into the system in terms of the quality and the suitability. You've then got to be thinking about who can see it, what's it for, why can they use it. That should then be reflected back to the tenants in that privacy notice. Here's what we are going to do with your information. These are the things we can legitimately do. And the way that GDPR works is if something happens that isn't in the list of things that it's appropriate to do, you're in a difficult position, because if you knew you needed to do it, you should have said so. And if you've done it without having said so, the assumption is it's something you shouldn't have been doing. So a lot of this is data protection impact assessment, DPIA. And if you are going to be taking, and I think you probably are in light of what we've talked about today with the standards and the Ombudsman's approach, if you're going to be collecting and managing a lot more special category and otherwise sensitive information about the tenants, that is a high risk processing activity in some senses. And some of your organizations will be doing it for tens of thousands of people. So that, to my mind, will probably justify running a DPIA. And that's an opportunity for you, your data protection officer, your compliance team, external advisors, should you need them, to say, okay, where does the information come from? What do we do with it? Where does it go? How do we keep it? Who can see it? Who do we share it with? And if we can identify all of those things are legitimate, other things aren't, then that's when you start putting down the controls. If you can, technically. If you can't, it's a matter of policy and training and enforcement. So I'll get down off the hobby horse now. But absolutely, this is daily stuff for us in terms of doing GDPR advice in the housing sector. It's not an intractable problem, but it is a problem you've got to grasp and get a plan for. I think it is, in terms of how you carry out a DPIA, there's no set way of doing it. What I would say is if you've got too much AI involvement, you potentially run the risk of your DPIA itself becoming a profiling or automatic decision-making type activity. And to avoid getting on the wrong side of that rule, you've definitely got to have the human involvement aspect of that. It can be a useful tool. No doubt about that. If it's helping you avoid laborious and time-consuming activity, and there's a sense check within the process, then as with all use of AI, and it again isn't the topic for today, you just don't let it rip on something without any control or planning. I think that's the main policy there. If you've got again, with all GDPR compliance, if you've got a plan as to why you want to do what you want to do and a good explanation of the mitigation and controls you have in place, then the ICO will at least give that a fair hearing if it does ever turn into a problem. Okay, well, I think we've trespassed on your patience to the tune of an additional 7 minutes. We've had some really, really good questions there, so thank you very much for those. If there are any others, when you get the slides and the recording, there's some rampant self-publicity for myself and Paul at the back of that. There's also a slide about our forthcoming event at the Bridgewater Hall next month, where we've got the RSH speaking, we've got Zurich Insurance, we've got BDO coming to talk about legitimate tax avoidance, so we all to know about that. But if it is of interest to you and you want to register some interest in that, we have events at forbessolicitors.co.uk, or drop an email to your usual advisor at Forbes, let them know you're interested in that event, and we'll make sure you get the full invite with the booking for that when it comes out. So thank you for your time and attention today. We hope you found that useful. Thanks to Paul for his valuable contribution. I know he spent a chunk of the weekend getting that ready, so thank you, Paul, much appreciated. And we hope to speak to you again soon. Thank you very much.
Thanks for coming, everybody. See you. Bye.